anxiety that surrounded this program even from the very first few hours and days, and that led to an even higher level, even what's now become even more public revolt, really, in 2004. If you speed up a couple of years, when at the bedside of Attorney General John Ashcroft, at that point there was a whole new cast of characters in the Justice Department, including Jack Goldsmith, who was the head of the Office of Legal Counsel, who looked at aspects of this program and determined that they were potentially illegal. He thought that the legal authorization given to this in the early days, which was sort of an afterthought, as I lay out in the book, was shoddy, slipshod, really just very a cursory review. He went back at it and refused to give his sign-off to the program because he thought this was unconstitutional. And this led to a dramatic standoff at the bedside of John Ashcroft, because Ashcroft was in the hospital after pancreatic surgery. His deputy was refusing to sign off on the program. Alberto Gonzales, who was then the White House counsel, and Andy Card, who was the chief of staff, go to Ashcroft's bedside to try and get Ashcroft to basically overrule his deputy and determine that this program is legal so they can continue doing it. So you see, as I try and lay out in the book, I mean, this was really, from its earliest beginnings, a constitutional crisis in the making over this program because of what some people saw as just a power grab in terms of the executive branch, in the view of some people running roughshod over checks and balances in the name of executive power.
Eric Lichtblau, Democratic Congressmember Jane Harman of California, was one of the members of Congress who tried to stop you from publishing the article. Can you describe what she said?
Well, what I lay out in the book, and what I can say, is that there was a period during the hiatus, as I call it, when the story was on hold, when the paper had decided it was not going to run the story, when I was covering a hearing, sort of in my day job covering the Patriot Act, and Harman had given a fairly eloquent defense of civil liberties and call for more checks and balances. And I didn't plan to ask her about the NSA program. I knew that she knew about it. I had the sense that she was a defender of it. And sort of impromptu, I asked her in the hallway how what she had just said at this hearing squared with her views on the program. And she was quite alarmed that I was asking her about this program in a Capitol hallway, and she shooed away her aides and said, "They don't even know about this. You shouldn't be talking about this here." And very quickly made clear that she thought that the paper had done the right thing by not publishing this story. Would not get into any of the details. I tried to ask her why she thought publication would harm national security and what about the legal ramifications here, and all she would say was that this was a story that should not be publicized.
Now, though she doesn't dispute the account, she did take issue with you saying her views on the program's legality changed after the story went public. She said, quote, "My views on the subject have not undergone a dramatic transformation. I have said all along we must protect the operational details of programs designed to learn the plans of foreign terrorists in order to prevent and disrupt those plans. At the same time, Congress must insist on ironclad protections of the constitutional and legal rights of all Americans." Your response, Eric?
Well, I do say in the book that her views underwent a fairly dramatic transformation. Look, I'm not looking to beat up on Jane Harman personally here. I think that she was in a difficult spot, as were the few members of Congress who knew about this, because they were given such limited access by the White House about this program. What was interesting to me, and says a lot about the ways of Capitol Hill in some ways, was that immediately after the program became public, Harman, who, as she says in her posting yesterday, was pretty much a defender of the program, quickly became a very outspoken opponent. So when I talk about her dramatic transformation, she went from someone who thought this was a critical program that should not be publicized to someone who attacked President Bush very aggressively and was raising all sorts of legal and constitutional questions. So I found that shift fairly significant.
Eric Lichtblau, Congress recently held a secret session. They have rarely done this. I think it was the 6th time that they did this. It was around the issue of wiretapping. What do you understand about what happened? And then talk about the showdown now in Congress, the standoff over telecom immunity.
Yeah, the secret session was, I think, the first one since 1983, since the vote on Contra funding. I don't know that there's a whole lot in the way of substance that went on in that secret session. It was, in some ways, I think, a chance for the Republicans to beat up on Speaker Pelosi, who at one point was one of the members who was given access to the program early on, although Pelosi did raise concerns about it and has since released a letter that was once classified raising concerns about what the NSA was doing. So my understanding is that the secret session, as far as it went, did not produce a whole lot in the way of new disclosures, even to members in a classified setting. We're really at a standstill. I think everyone is amazed that there has not been a resolution on the whole NSA issue this late in the game. You know, it's now been almost 2.5 years since we first disclosed the program in the paper. We've had 2.5 years of almost constant debate on the government's spy powers, and it looked almost certain 6 months or so ago that the White House would succeed, as it has done on any number of other national security issues, in getting the type of legislation that it wanted. It got a plan through the Senate that would not only broaden the government's surveillance powers, give them the ability to get broader, what they call basket warrants, rather than having to establish individual probable cause to look at broad groups of people at one time. It not only did that, but it also gave the key factor of retroactive immunity for the phone companies, meaning that those phone carriers, AT&T, etc., that took part in the program after 9/11 would be protected from the lawsuits that are now pending against them. There are some 40 or so lawsuits. That has been a key priority for President Bush and his administration, is protecting the companies from legal liability. So it got that through the Senate. The House has held its ground, which has surprised a lot of people who, especially on the left, who have criticized the Democrats for, in their view, caving to the White House on national security issues, or on any number of national security issues. And so we're at a standstill, and there's no sign at this point as to which side is going to blink first.
Eric Lichtblau, explain how you lost your press pass.
How I lost my press pass. That actually predated the whole NSA story. That was when I was just covering routine Justice Department issues, and there had been a number of run-ins with the Justice Department during Attorney General John Ashcroft's tenure over stories that the department felt were too critical. And there was one in particular when I wrote a story about the FBI gathering intelligence on anti-war demonstrations, over Iraq anti-war demonstrations, and that was a story we put on the front page. It was an exclusive involving some internal memos that had gone out, an alert that had gone out to field offices, describing tactics, many of them lawful tactics, that anti-war demonstrators were using. And the Justice Department and the FBI were not at all happy with that story and let me know it. And I showed up for an interview a few days later. There had been some back and forth with my bureau chief, heated exchanges between Ashcroft's aides and my bureau chief. I showed up for an interview, and my press pass had been confiscated by the Justice Department. And at that same time, the FBI had put out an internal memo to its people advising them not to talk to me anymore.
In the stories, you expose the spying on, well, groups like the Quakers and the Truth Project, dealing with issues like taking on military recruiters in schools. Right.
Yeah, it's part of what I describe in that chapter of the book as really just sort of a general paranoia, I think, of anyone who could be considered a threat. And this had really bled down from the highest ranks of the government, that whether it was the person, whether it's the person getting on the plane, whether it's the protester at the corner, whether it's the person at the college campus, if there's any sign that someone could be considered a threat, they have to be treated as a threat. The 1% doctrine, Ron Suskind called it, and attributing it to Dick Cheney. I think this was an attitude that really bled down even to the local cops who were part of the Joint Terrorism Task Forces that work with the FBI. Before, someone might have gotten might have gotten an odd look from a police officer and thought nothing of it. Now they'll be entered into a database, and in the case of the military database, they collected upwards of 280 files on peaceful anti-war groups, and these were files on groups that had done nothing more than protest against the war.
You also write about how the tensions increased over your piece in June 2003 when you wrote a story raising questions about the role of Mike Chertoff, who is now the Homeland Security Secretary, playing in the decision not to give John Walker Lynn access to a lawyer in Afghanistan.
Right. That was sort of the beginning of the end of my troubles with the Justice Department. I wrote a story about an internal whistleblower, I would call her, at the Justice Department, Jocelyn Radick, who had raised concerns about whether or not Lynn's due process rights had been violated. And Chertoff, who was at the Justice Department as the head of the criminal division,